Hey, Andrew, can you tell me a little more about depositions and personal injury cases?
Sure. Uh, Depositions in a personal injury case are critical pieces of the pie. And let's start out by just trying to answer the question, what is a deposition? Well, a deposition is a transcript of testimony taken by an attorney of a witness or a party under oath that is transcribed, put into a booklet, which has a series of questions followed by answers. And that transcript is then memorialized in the case and can be used for various purposes. Now, we call them depositions in Florida. Different jurisdictions call them different things. In New York, I believe they're called examinations before trial. Other places call them sworn statements. But here in Florida, they're depositions. And usually, uh, these depositions are conducted by an attorney who is on the opposite side of the case. And they they can be very lengthy, they can be short, but they are important because you're under oath, and the deposition, whatever you say in that deposition, you're married to it, and it can be used at the trial to impeach you. It can be used to refresh your recollection, or in appropriate cases, it can actually be read to a jury and introduced as testimony in the case as if you were stating it yourself. Now, why do you have to give a deposition? Um, it really falls into two categories. I really want to focus on depositions by parties, by plaintiffs in personal injury cases, but witnesses give depositions as well. And you have to give the deposition if you're a party because the rules of civil procedure require it. So when the opposing counsel sends a request for your deposition, it's called a notice of taking deposition, you have to appear at the time, which is usually mutually agreed to, and you will be asked questions by opposing counsel. Now, if you're a witness, then a notice of taking deposition needs to be accompanied by a subpoena, which is a court order that directs you to appear to give your testimony. Now, you can voluntarily give it, so a subpoena might not be necessary. But if you're just a witness, you're only obligated to give that testimony either voluntarily or with a subpoena. But these depositions are important. As I mentioned a moment ago, they can preserve your testimony. They will help refresh your recollection if your actual court testimony occurs months or years after the date of the deposition. And once you have made a statement in your deposition, as I stated before, you're married to it, meaning you can't change it. The uh, only thing that you can do to modify your testimony is to complete what's called an errata page. And that errata page is a separate document that indicates the page and line of the question and answer that you wish to change. Now, you can't just make the change and ignore the reasons. You're required to explain those changes as well as uh, the reasons. And the attorney for the other side becomes entitled to retake your deposition as to those areas to further examine why those changes were made. But let's talk about some general guidelines. Okay, so hypothetically, you're in a case and you've got a lawyer, and your lawyer, okay, should say, hey, we have to have a pre-deposition conference. So what are you going to be told by your lawyer? You're going to be told that the purpose of the deposition, okay, is to discover what you know about the events leading up to your injury. The deposition is also going to be used to evaluate your credibility, your demeanor, and how you may appear to a jury. In other words, the opposing counsel is going to eyeball you and see what kind of a witness you would be in front of a jury if the case were to go to trial. And finally, the purpose is to gather information about the extent of your injuries and the effect that those injuries have had on your life. So, what do you need to be told? Well, number one, you have to be told to tell the truth. Okay, you're under oath, and honesty is absolutely required. You don't want to guess about anything. You don't want to speculate about anything. And if you do not know or can't remember something, it's perfectly acceptable to say so. Guessing is one of the worst things that you can do. Now, listen carefully to each question and don't begin answering until the attorney finishes asking the question. Take a moment to think about what you're going to say before you respond. Now, when the attorney is speaking, you can't speak at the same time because the court reporter can only take down one person accurately. You also need to verbally respond and not just nod your head or say uh-huh or uh-uh. You need to say yes or no so that the court reporter can get an accurate record of what you're stating. Okay. Uh, Answer only the question that you're being asked. Uh, don't volunteer additional information. If the question can be answered simply with a yes or no, uh, do it and stop. If you need to explain your answer, however, you can explain your answer. If the attorney needs a follow-up after you say yes or no, the attorney has the obligation to ask those follow-up questions, but don't volunteer additional information. Just answer the question. If the question is it raining? You just can state yes or no. You don't have to say it's not raining now, but it's anticipated that it's going to be raining within an hour, because that's not what the question is asking for. So don't volunteer additional information. Now, you want your answers to be accurate and precise, but you don't want to talk in absolute terms. So avoid stating things like always or never when you're asked about what can you do or what have you done. Okay. There are very few things that you cannot do at all, but there may be many things that you can't do as well as you did before. So make sure, okay, that you're clear about that. And if there's something that you cannot do anymore, then you state, I can't do that anymore. If it's something that you can't do as well, state that I can't do that as well. Okay. And just be careful about committing yourselves to an always or never, because at some point later in the case, there may be surveillance, which you may be found doing something that you said you never do, when in fact you do it occasionally. So you have to be accurate and honest about what you're testifying to. And when you're talking about things like time, distance, or other measurements, only state what you know to be for certain. Don't guess about those things. Now, you want to also maintain your composure. One of the things that lawyers often do in depositions is they try and push your button. They want to see if they can get a certain response from you, because that may make you look, okay, bad in front of a jury. So don't let the lawyer get to you. Just maintain your professional response, okay, an even keel, and don't let the lawyer get under your skin. Okay, your behavior is being evaluated. And very often these depositions are not only just paper transcripts, they're also videos these days. Quite commonly, they're videos. And so the way you respond could be shown to the jury later on. So don't let the lawyer get your goat. Okay. Just be professional, keep your calm. Okay. Now you can take a break if you need to. You don't have to keep going. If you need a break, you ask for a break, you take a break. You also have the ability to refresh your recollection. For instance, if you've answered uh, questions, written questions called interrogatories, which is another aspect of the discovery process, which the deposition is just one part of, you can refer to those interrogatories. If you're uncertain about where they are, ask your lawyer to give them those interrogatories to refresh your recollection so that you can be consistent with what those interrogatories say. Because the interrogatory is a written answer, also under oath, that can be read at trial. Okay, and so you want your verbal testimony given in your deposition to be consistent with what the written answer to the question was in the deposition. Now, also, since this could easily be videotaped, or it's not videotaped anymore, but recorded, You want to dress appropriately. You want to usually wear business casual attire. You don't want to you don't want to wear excessive jewelry. You don't want to wear anything that's provocative or anything that makes you look like you're inappropriate for the circumstance. So usually, okay, a collared shirt if you're a guy, or a modest blouse or sweater if you're a woman, and just don't do anything that's over the top. Just appear professional in your appearance. Do you have to wear a jacket and tie? No, you don't have to wear a jacket and tie. You can if you want, but it's not necessary. Just look professional. Uh, the last thing that you want to cover is uh, don't guess or exaggerate. Okay. Uh, Exaggeration will come back to bite you. You want to just be honest and straightforward and just tell it the way it is, and discuss your current limitations honestly, and be prepared to talk about how your limitations or your injuries have affected your daily life, which would include work, home, activities, hobbies, your emotional well-being, your relationship with your spouse or significant other. Don't minimize them, but also don't exaggerate them. Just be honest and straightforward. Now, the topics that usually depositions will cover, okay, will be your background, your education, your work history, your family, how the incident occurred, the details of your injuries, and the medical treatment that you sought, the names of your doctors, and what they've done for you. And again, you don't have to remember everything, okay? If you can't remember something, just tell the opposing counsel who's asking your questions, I'm sorry, I can't remember that right now, but if it comes to me, I'll let you know. Okay, that lawyer will know all your doctors simply by making written requests to your attorney. So you don't have to identify them all in your deposition. Just do the best that you can by giving the names of those that you can remember. Okay, and you're going to detail your injuries and your medical treatment, but you don't have to get into totally precise descriptions of everything that occurred because those are going to be in your medical records. But don't deny things that are in your medical records. Don't deny past injuries, certainly, and be honest about what your past medical history has been. Uh, you want to talk about uh, any prior injuries and medical conditions. And if you don't talk about them and they're discovered later on, that can result in the imposition of various sanctions from the court because you've not been honest about what's happened to you. So that basically sums up what you need to be aware of when your deposition is taken. In virtually every case, that is filed at court in court, there's going to be a request for your deposition. So you should expect it. And if it's taken far in advance of the trial, there'll probably be an update deposition that's taken to cover events in your life that have happened since the date of the last deposition. But you shouldn't be afraid of it. It shouldn't make you overly nervous. And if you just answer the questions honestly and be yourself, and answer the questions calmly, you should do just fine. I hope this has been helpful. And if you've got a lawsuit going on, you should be sure to ask your lawyer about how you can prepare for your deposition. Have a great day.